I will call 125-573, State of Kansas versus Larry D. Huggins III.
Hey, please the court. Again, I'm James Latta of the Appellate Defender's Office representing Larry Huggins. We're here straight to this court on a felony murder and multiple other convictions. And as a brief reminder, this case arose from an alleged botched robbery where some teenagers, Mr. Huggins at the time was 19 years old. And this is an alleged botched robbery where they were trying to get some guns from another teenager. And in doing so, there were shots fired from both parties, and one of the victims ended up dying. So I plan to start with kind of my first three issues, as they all kind of have the same underlying premise. But I always like to tell this court, if there's a certain issue this court wants to talk to, I please ask this court to direct me there, because I always want to talk about what this court wants to talk about. So for my first three issues, the underlying premise is the same. It's specifically for the attempted aggravated robbery charge. The state charged that Mr. Huggins attempted to rob OH and ZM. And based on that, my argument is the state had to prove that Mr. Huggins attempted to rob both. And probably my best case for that, I think there's two cases that when you read them together. First, we have maybe even three. We have Fitzgerald, which was the 2018 case where we said that the charging document controls. We have Couch from 2023, which reiterated that when the jury instructions do not accurately recite the statutory elements of the crime or do not match the elements of the crimes as charged, we hold the state to the crime, to proving the burden as charged in the charging document. And then in my reply brief, I cited Daniels, it's a little bit of an older case from 2004, where this court actually performed a sufficiency analysis for a crime where they charged two victims, and this court performed a sufficiency analysis to see if the state proved that the crime had been committed against both. So that's my underlying premise for all three of my first three issues.
Where is it that the statutory elements weren't instructed on? That's what that's where it breaks down for me, Mr. Latta, is that the jury was properly instructed on the crime. All the elements were there. And I guess it's your argument that the state is stuck with whatever's in the charging document that supports the elements. I don't know where you're getting that from, because
Sure.
Tell me your path.
Sure, Your Honor. So my argument is that when the state charges something in the charging document directly related to the statutory crime, that's what they have to prove. And for an example, if they would have separately charged that Larry Huggins attempted to rob ZM, this court would hold there's insufficient evidence of that charge. In the robbery statute, it says person or any person. I can't recall a case where I've ever seen a charging document omit the alleged victim. I mean, that's what the instructions say. That's how the instructions read the crimes of Kansas. We put in there, we say the defendant committed this, and we also say against this victim. And when the state charges two victims in one document that goes directly to the crime, that's what they have to prove. Now, they don't have to prove every little thing they put in the charging document. If the state, because I've lost this issue before, if the state puts in a defense or something that's on the defense, they don't have to prove that. I've lost that issue. But the victim goes directly to the crime as charged. And in Kansas, I don't think we could be any clearer that we have to have something we look at to know whether or not the state met its burden of proof. And in Kansas, that's the charging document. And so that's my underlying premise. And then from there, that's where I draw on my instructional issue and my sufficiency issue. So I think the sufficiency issue, which is issue 3, is straightforward. There's no evidence that they attempted to rob ZM. And because of that, the attempted aggravated robbery charge has insufficient evidence. And any of the other charges that incorporate that in, there's either an alternative means issue where there's insufficient evidence that would require reversal and remand. Now, for my instructional issues, the
But
first,
hang on.
Yes.
So even if, I don't necessarily agree with your first premise that that the right to a jury trial requires, I guess, every factual allegation in the charging document be submitted to the jury, that instructions can't have different facts than those alleged in the complaint. But even if we accept your premise is true, when you look at the evidence, it's your position that the jury would have acquitted him if instructed it had to find that he attempted to rob both the victim and, I have it down as victim's friend because I was getting confused with all the initials and all that stuff.
sure,
So I use these words. Okay. I don't know these. Okay. So I called somebody, the person that initiated the scheme. I called that the schemer. Okay. So the day before, the schemer sent the defendant a picture of the victim, and said, look, the victim owns the guns, the marijuana, and the money. He also sent a picture of the victim's friend, in which the victim's friend is holding the victim's guns. They talked about how to steal them. The schemer testified that defendant told him they should smoke with them and then take their SHIT. Defendant confirmed this on the stand, testifying that he intended to take guns, money, and weed from those guys. Victim's friend testified that during the robbery, defendant's friend came into the bedroom, brandished the firearm, and asked where the big gun was located. Victim's friend told him, there it is, and they grabbed the gun. Why doesn't this evidence support a finding that defendant attempted to rob victim's friend? Although they didn't seek any property that the victim's friend owned, our past cases have made it clear that possession or control over property is the necessary element, not ownership.
sure. And my argument is that ZM, which was the friend, I think, as you're calling him, did not have any possession or control on the day of the attempted robbery. That picture was taken before. That was a fun picture. They were taking.
The big gun was in the room with him.
Right. That is not in his control.
That's not in his control?
No, ma'am. If we were going over there if I went over to this guy, to the victim's house and said, can I please borrow this gun? ZM has no authority to grant me that permission to take that gun. He has no control over it. It's standing in the corner. It belongs to.
Then you're
the
saying ownership. That means you don't have control over it because he doesn't own it. But that's not what our cases say.
I think they talk about ownership and control.
So it's possession. Our case laws have made it clear that possession over property is the necessary element, not ownership.
Okay.
Possession or control. It seems
Sure.
to me that, if I'm in a bedroom that's not very big and the big gun is behind the door right over there, and I'm the only person in that room and I'm the only one that knows where that gun is, I have possession and control over that gun.
I would respectfully disagree. I mean, just because something's in my reach, I don't have possession over anything around here.
What, do you have any cases to rely on to say that? Because it seems like all of our cases, like in a car, you have possession and control. It seems like all of our cases say.
Sure, I could cite State v. Schuerman, where court said the passenger is not in control of the car.
But things within a car.
I mean, they're not in control of something that's not theirs, and they're not actually touching it. I'm not in control of everything that's near me.
What about a purse? That's not mine, but I'm in the passenger seat and there's a purse right below my feet. And it's not mine. I don't own it, but do I have possession and control over it? Doesn't our case law say yes?
I mean, I'll concede we're getting closer. I don't necessarily want to concede the whole thing.
Okay.
But we're getting.
Before you sit down, I don't want to short circuit you on the first kind of three issues and the issue that you present, but I want to direct you to the voluntariness of the confession and the 3 to 4 hour period preceding the statement. What's your best argument that those conditions rendered whatever, I don't know, it really wasn't an inculpatory statement, whatever statement he gave to the detective as involuntary? Explain to me your position on that.
Is my position is it's his mental states, number one. I mean, if you watch that video, I mean,
I've watched the video and I've watched a lot of the conduct that occurred during the period of time. Articulate to me what it is. Is it the kind of the exhaustion, the fact he slept, the fact that he was agitated at times, the fact he
Sure.
urinated on the floor? What is it? Is it just the combination of all of that? What is it?
definitely the combination, and it's also from a common sense viewing of that. You can tell he's not just sleeping, he's passed out. He passes out sitting upright. A reasonable person viewing that video, and I usually don't say this, but a reasonable person viewing that video would know he's out of it completely. You know, from the first time he wakes up, you can tell he doesn't know what's going on, stands up, you have no idea what he's doing. He doesn't attempt to get any officer's attention, and he urinates all over the floor. A fair viewing of that, he has no idea where he is. Then he goes and knocks on the door, and he asks the officers where his visitors are. I mean, throughout the entire interview, he does not just sleep, he passes out, and you can clearly, and I mean, the district court made findings that he was under the influence. So, I mean, I think, I'm not even asking you to review the video de novo, which I know this court won't do. The district court made findings that he was under the influence, but they just came out with the wrong conclusion in the end.
Okay,
And
so
that-
it's your position that that it was that the statements that he made were not knowing and voluntary? Is that? And so they
Yes.
shouldn't have been introduced?
At all, yes.
Okay. And so, this court just recently issued an opinion in GO. Did you have an opportunity to read that? And to me, that the first thing under GO that you have to find is coercion or misconduct by the police. And then you have to link the coercion to, we said the confession, because in that case, there was a confession. Here, there is no confession. It's just, I guess, statements that were made that would be used against him, at trial. But it wasn't a confession, but I guess. But where was the coercion? Where's that misconduct by law enforcement?
So in my opinion, the misconduct is the officer performing the interrogation of a 19-year-old teenager who he knows is completely out of it. I mean, when you're out of, this teenager doesn't have a clue where he is, and he's trying to coerce a confession out of him. That, in my opinion, is the misconduct. When you have an adult police officer in a role of authority, and you have a 19-year-old teenager in a room in extreme pain, which you can tell by the video, and also he is completely out of it. That's the coercion to me. And then I would also add in there that harmlessness is not a factor. The state failed. If this court finds error, this court has to reverse. The state failed to argue harmlessness in issue 4, and it failed to even mention harmlessness in issue 5.
Standing alone without I'm sorry, did I interrupt you?
No, go ahead, Your Honor.
Standing alone without considering the characteristics of the defendant Huggins, did law enforcement commit any misconduct?
So in my opinion,
Overreach, any misconduct or overreach?
so in my opinion, the overreach is interrogating a 19-year-old when he's clearly under the influence.
Okay, you're
and doesn't know where he
considering the
is.
characteristics then of the 19-year-old without considering those characteristics.
Sure, I understand
Just
that.
what the officers did. Was there anything that you consider to be misconduct or overreach?
I would say interrogating anyone, regardless of age, knowing they're under the influence to that degree, making a person wait in pain to that degree for 4 hours, intentionally or unintentionally, not asking the person what he's under the influence of. So maybe they can deny later knowing what they're under the influence of. Those would be my answers to your question.
And what impact would the second interview that took place a couple of days later? He was free to leave. I mean, he left after the first interview that day, came back 2 days later, re-Mirandized, and gave another statement somewhat consistent with what the first statement was. What impact does that have, if any?
Well, it could have a significant impact if the state would have argued harmlessness, but the state didn't. I mean, I have a case from this court that I found, State v. Torres from 2012, 294 Can 135. where this court held that the state failed to argue harmlessness, they waived it and they lost. And this court reversed. And in my research for this case, I found multiple cases. I found lots of cases from the Court of Appeals. I found a case from this court where this court has said that in the 1507 context and, you know, make an affirmative showing of excusable neglect, this court has said that the defendant has failed to meet that burden with a conclusory statement. State's entire harmlessness argument on the voluntary statement is conclusory. And the burden of proof in those other cases I'm just talking about for the defense is not even beyond a reasonable doubt. If procedural fairness means anything, I mean, if this court finds error, this court has to reverse. Just under the general principles of procedural fairness and harmlessness that this court holds the defense to in the cases I was just talking about.
One real quick question before your time's up. If we agree with you on your sufficiency claims about the attempted robbery, et cetera, what is the impact on the felony murder conviction from your point of view?
As argued in my brief, this court would have to reverse it admittedly on alternative means grounds because you have it said the underlying felonies for that were the attempted aggravated robbery, which would now be insufficient. And then so therefore you have one alternative means that's insufficient. I also.
Why is, I mean, a felony murder conviction does not require a conviction for the underlying claimed felony. It's part of the element of the felony murder.
That's correct, but there still needs to be sufficient evidence of the underlying felony. And there's not sufficient evidence in this case.
Was the felony murder charge instructed the same way as is that your argument?
Yes, it incorporates the attempted aggravated robbery instruction, which in my argument is erroneous. And then the felony murder instruction says, you know, someone was killed by these felonies, and then it says attempted aggravated robbery and or.
So you're relying on sort of the super sufficiency type of analysis.
Yes, Your
that
Honor.
we've done in alternative means. Okay.
And just one more, your theory is that ZM wasn't charged in the attempted aggravated or in the aggravated robbery, but the same instructions did not, or the charging document didn't include ZM in the burglary or the conspiracy to commit the burglary. Why does that argument follow for those particular underlying felonies?
Because the aggravated burglary incorporated the attempted aggravated robbery charge and instruction. Because they said, as we all know, a burglary can be committed by a felony or intent to commit a felony or sexual crime or theft. And for that part, the state in the instruction said the attempted aggravated robbery referred back to the erroneous aggravated robbery instruction and then also said or theft. So again, my argument is on alternative means grounds that also fails. If there's no other questions, Your Honor. Thank you.
Good afternoon. May it please the court, the state appears by Jody Litfin, Deputy District Attorney. I guess I'll go ahead and begin with issue 4, which is the voluntariness of the defendant's statements. And we went through in the brief the different factors that the court looks at. And we look at the totality of the circumstances in determining whether these were voluntary. And the state's position here is that the district court got it right and found that these statements were voluntary, freely and intelligently given. If we look at basically the defendant's argument is it was unfair that he was interviewed after going to the hospital after he was shot. It doesn't say anything about the detective's techniques, coercion. He doesn't say anything about threats or promises being made. This is certainly not like the case of Geo, where they found some sort of coercive tactics were done by law enforcement. If we look at the facts, he'd been shot that afternoon. He was brought to the hospital around 6 p.m. and got treatment, released from the hospital, transported to the law enforcement center around 7:40 p.m. and stayed there until 11:30. And as we saw in the video, he just mostly slept.
But
So-
you're not suggesting, though, that the characteristics of the defendant can't alone be enough to evidence coercive conduct, are you? In other words, if you've got a defendant that's hardly conscious and under the influence, and law enforcement is aware of that. That's the distinguishing fact, right? That law enforcement has to be aware of that fact. Continuing questioning, that can be, can that not, that, there are a set of facts where that can constitute coercive conduct.
Yes, I would agree with that. I think that here, had the defendant not been able to answer questions appropriately, like the detective's testimony about, I was talking with him, he didn't appear overly drowsy, he wasn't falling asleep as I was interviewing him, his questions were appropriate.
Your
Um,
argument is this is not this case, right?
Yes,
Okay.
correct. I mean, there could be a case, sure, where they're completely not making sense. And I think the detective even admitted, had he would have dove deeper into what medications he received or what he had been taking if his answers weren't making sense, if he wasn't tracking what was going on. He questioned, the honesty of his answers, but they were appropriate. And certainly we can see in the video that he's talking about his girlfriend. He's talking about his stepmother, addresses, names, phone numbers. I mean, he's able to rattle off all of that information, some correct, some incorrect, and certainly tell the law enforcement officer that he was shot at 6th and Locust or 6th and Lime by some unidentified black car. So he was giving appropriate answers to the detective's questions. And I don't think I don't think the detective had to ask, because it was clear from speaking with him that he was understanding what was going on.
So are you arguing that then the fact that the officers waited then made it appropriate for them to ask as they did? By the time they were asking him questions, he was better? Is that what you're saying?
I don't know that that's the day. I just know that there was a period of about 4 hours where he was sleeping, and certainly woke up and was able to talk to the detective in a coherent manner and was not, actively falling asleep while he was talking to him. I don't know if that cuts either way of the medication had kicked in and so he wasn't in pain, or if the medication had worn off so he was more coherent. I don't know that that really cuts either way.
Would that justify the officers keeping him during a period of time when he is really not coherent, competent, passed out, as Mr. Latta indicated?
I didn't think about really the amount of time. I just know that what the detective said is that wasn't uncommon. There was just testimony that this is kind of very run-of-the-mill for these types of investigations, that they're doing a lot of fact-finding in that time. And I don't think that time, I think that just has to do with the other investigation that they're doing, and what other evidence and facts that they're gathering before they come and speak with the defense.
What, just address briefly the harmless issue. Did you not raise harmlessness?
I thought on page 34, I raised harmlessness. Now, if the defendant wants to say that it was a conclusory, if we just threw it in there, because I think I was at my 50 page limit. It does, I did in the last paragraph on page 34, the state says, if it determines that any error in denying the motion to suppress, that the error was harmless. And then I just say, here, even without the interview, the state's evidence was overwhelming against the defendant. And I think I'm not sure if it was the third issue or the first issue, one of those issues, the state goes through all of the evidence as well as the facts. So I think that we did preserve the harmlessness. I don't know that I have any further presentation unless this court has questions.
Well, why don't you address the first three issues?
Okay, as to the first issue regarding the structural error under section 5, first of all, we'd argue that this was not preserved before this court. Recently, certainly, this court has been using its discretion in not addressing issues that were not raised before the district court. The defendant here did not object to the attempted aggravated robbery instruction. And although he does claim that 2 exceptions apply under Gray, it's a prudential decision, and this court can still decline not to address that. And we would argue that, or contend that that is the decision this court should make and not even get to the issue because it wasn't preserved. If this court does get to the issue, our position is that this wasn't a total missing element, I think is how the defendant has argued it, holding the state to what was charged in the complaint OH and ZM, and then having the instruction only list OH. Our position is that if you look at the statute, which is what we're bound by, the state included all of those elements in the instruction, I'm sorry, in the complaint, and then included all of those elements in the jury instruction as well. So the element of robbery is taking property from the person or presence of another person. And then the people that were robbed are merely facts to support that element. So our position is that there was no missing element here. And it's not structural error under Section 5 of the Kansas Constitution. And in fact, I think this court, I think in, or if it's Couch or Fitzgerald, it almost seems here that the state was doing a narrowing of the complaint, which this court has held that is something the state should do. You should narrowly tailor the evidence, which again, our position is that the evidence supports both, an attempted aggravated robbery of both. But I don't see any cases where this court has held the state or found it error to narrow something in the complaint. Certainly broadening is not permitted, but narrowing is okay. And also we argued alternatively, if this court does find that this was a missing element and the state was bound to OH and ZM, that this is not structural error. And we cited to Nieder and some other cases, that's in a United States Supreme Court case, and some other cases which have held that this is subject to a harmless error analysis. And so that's where the state's analysis of there was sufficient evidence also to convict ZM of that attempted aggravated robbery. So we would hold that this is not structural error. Under Nieder, this court can do a harmless error analysis. For the second issue, we relied on the entire argument from the first issue, just under a clearly erroneous standard of review. Again, there was no objection here at the jury instruction conference to this instruction. So we would hold that the instruction was factually and legally appropriate and that there was no error, let alone clear error. And for the third issue, there's kind of three different arguments that the defendant made. We would argue again that the not including ZM does not make the aggravated robbery, not make the state. We still presented sufficient evidence of the attempted aggravated robbery of OH, and not including it is not error. Not including ZM was not error. And for the aggravated burglary, I think the state has made the argument before, talking about the underlying felonies that were listed in the instruction being alternative means. It's our position that those are options within a means and that we don't have to distinguish which felony we're relying on for the attempted or for the aggravated burglary count. The Court of Appeals and this court, I think, have both held in cases or assumed that the listed felonies underlying the ag burglary were alternative means, but as we pointed out, there is no opinion going into that analysis. It's always just been an assumption. I think we argued in State versus Reynolds, which I think is still pending before this court, that this court should find that there were, that those alternative listed felonies are not alternative means. And then as far as the felony murder, we would argue that there was sufficient evidence presented for each of those means. And so that this court can uphold that conviction under each of the alternative means there. And again, I think I'll just rest on the prosecutorial error issue. We conceded the bids fee issue, so that does need to go back for a remand for those proper findings to be made by the district court. I don't think I have any further presentation.
Thank you.
May it please the court. My only rebuttal is if this court thinks that a conclusory statement is enough for harmlessness under the voluntary statement, then I direct this court to the issue after that, which is the Facebook records where harmlessness isn't even mentioned at all. There's a standard review isn't even listed. And so under the Facebook records, regardless of the harm, we also ask for reversal under that. And unless there's any questions, I just ask this court to revert.
Briefly on the Facebook records, speak to me about preservation, because as I understand it, there was an counsel initially, I don't know if appointed or retained, Mr. Conwell, had a suppression hearing on the kind of a Fourth Amendment concern about specificity of the warrant. That was denied. Later, Mr. Shepard is representing him in a separate issue regarding foundation of the records. And the district court said, well, I'll put that on hold until we get to trial, as I understand it. Is it Mr. Spies or Mr. Spice? I'm not sure how to pronounce his name. Raises basically the same objection, renewing Mr. Shepherd's objection, and kind of makes no mention. There's really nothing to do with that initial kind of scope of the warrant and that. I'm having trouble seeing how the district court had any opportunity or was alerted to anything regarding that initial hearing of Mr. Conwell's, and which was denied.
Sure, so my
Why,
best,
why is that even before us?
so my best argument for that is we all know the purpose, this court has reiterated recently, the purpose of 6404 is this court's a court of review. We need a ruling. And based on this court's case law, we look at the totality of the circumstances. And I think in some recent cases, Crudo, CRUDO, this court found that it was substantially complied with. And some other cases, Bentley, which is a 2023 case, this court found that although an objection was rather oblique, it was still preserved. And I say that to say this, is that while this court requires a contemporaneous and specific objection, we don't require a perfect objection. And so my best argument is under the totality of the circumstances, where we clearly have a ruling for this court to review from the pretrial. We have defense counsel who, when he asked to come to the bench, he says, I have a number of issues. He goes through and he lists them. And then at the end, he says, and I want to refer to arguments, plural, and pretrial motions, plural. There was only one motion filed on authenticity and reliability. And he refers to motions, and this court has held that referring to pretrial motions is specific in other cases.
It didn't specific, he didn't specify the specific nature of what he was, that's fine. I understand.
I
your
understand, Your
position. Yeah, okay, thank you.
If there's no other questions, I ask this court to reverse consistent with my brief, please.
No questions. Thank you.
Thank you.
Thank you to both counsel for your arguments. We will take this matter under advisement.